I was having a meeting. But unfortunately, I see that only 40 of you are here out of 400 students. You can see how serious you people are. 40 out of 400 students, or almost about 400 students. I don't know. Anyway, I'll continue. I will teach what I want to teach, and then we'll see how it goes. We were talking about registration. I think the last topic I tried to let you know effect of non-registration, and I said, aside from the fact that document, a registrable instrument that is registrable, that is not presented for registration within 6 months is void under the law. Various land instrument registration of Lagos states or other states also have similar provision in that regards. You can find it under section 15, and then you have his other states also. And then we also said that it also give an acknowledgement of receipt. That's another effect of having a document register. Priority rather. It also create priority, and then an unregistered document will lead to an equitable interest. And we also talk about the admissibility of document that is not registered, that is registrable but not registered. And I try to let you know distinction between tendering a document as an evidence of purchase, or that is receipt, and then tendering a document as an evidence of ownership. Okay, they are not the same thing. I try to distinguish that one and explain that one to you. And then I also mentioned the case of Benjamin Kalio, and then I think Abdullahi, the case of Abdullah and Adetutu, okay, which is also 2 cases decided by Supreme Court in that area. And those 2 cases actually contradicted themselves, because one is talking about the fact that evidence can be a federal law. A state is not empowered to legislate on evidence. But unfortunately, the case, the matter was, the decision was reversed in Adetutu, which has been the old and settled principle from Supreme Court. Now, registrar of title, I said to you by giving you an inaugural one against Aderemi, and I said, there's difference between registration of instrument. An instrument can also be delivered for registration. But when you have a registration of title, we say that it makes conveyancing more cheap, more simple, reliable, and then it also solves you from problem of searching or looking for what we call abstract or epitome of title, because you can easily go to land registry when the title is registered, and then you are likely going to find out about who owns the land by mere putting the registered title, number to them at the land registry, and they are going to tell you, this XYZ is the owner of that particular piece of land. And then we said it make conveyancing more simple, more cheap. And then we also talk about the fact that you will know whether the buyer or the seller is actually have power to sell, and there's no encumbrances on the land or any overriding interest. Then you also know the issue of bona fide purchaser when you conduct the search. I gave you the case of Onoguro against Aderemi. Now, in Lagos State, land registration of Lagos State, that is the land registration law 2015, which replaced part of aspect of Land Registration Act of 1935. Okay, the first law in Nigeria about registration of title is Registration of Title Act 1935, which is applicable to Lagos State as amended. Okay, and then it's also adopted by many states. So each state have its own registration of title, the same way they have registration of instrument. Okay, now in Lagos State is only one. They don't call it registration of instrument, rather it's a registration of document. That's section 2 of land registration law 2015. Now there are 2 types of registration. There's compulsory registration and there's a voluntary registration. Okay, compulsory registration, these are documents, any documents that convey a whole estate in land. Any document that convey a whole estate in land is compulsory that has to be registered. Meanwhile, because there's no old estate anymore because of Land Use Act, so it means right of occupancy. Okay, so any right of occupancy after the commencement of Land Use Act, when the consideration has been paid, so it's also registrable. That's what we're saying. Then a lease that's granted more than 40 years is also not let them also registrable. An assignment of a lease is also registrable. I think by now you know the difference between a term of years and an assignment of a lease. I think I explained that to you. Assignment foreclose reversionary interest. Okay, that's what they call merger of interest. But term of years still gives opportunity to the landlord to exercise the right of reversion. Then you also have voluntary registration. These are power of attorney, for example, is voluntary when you are not empowering anyone to execute any document on your behalf, or any other power given to somebody to sell a property is also not compulsory to be registered. Now, what is the process of registration? There's what we call first registration. The first registration is what you have to file. You have subsequent registration also. What I meant by first registration is that you are the first to register that title. Okay, we call it first registration. So you are the one that delivered the title for registration. If X has obtained a right of occupancy, for example, what is he going to do? He will apply for full registration and he will go to the register of title. Okay. Then what does the register of title do? Register of title will investigate your title as applicant. Okay, that is his duty. The duty of register of title is not to determine title, but rather to investigate your title. Okay, and then he will now advertise. He's going to advertise to the whole world that XYZ has applied for registration. Okay, has applied for registration, and then usually the place on newspaper. If you have been seeing it, you see where people apply for certificate of occupancy, and then because eventually to go for registration. So you are going to see where they will advertise in the newspaper, and they will list properties, the name of the applicants. It will usually in the newspaper. In Lagos State, they use the Nation newspaper, and they want you to raise objection to such advertisement in case you are against such registration. Okay, so in case you are against such registration, you have to file an objection to it. That is one aspect. Okay, now so in investigating the title, register of title is only going to look at the document you submitted, your survey plan, and then if you're satisfied, you register you accordingly. If there's no objection, okay, so if there's no objection, it's going to register you, and that is his job. You can read the case of Onosile against Idowu. In Onosile against Idowu, the court is of opinion that register of title has no power to determine title. His interest is just to investigate the title as stated. Okay, when that title is investigated, the next thing that will happen is that if you find out he's satisfied with the conveyancer, he's going to register it accordingly. Okay, so that also depends on the nature of title you want to register. If it's an adverse possession, what happens? An adverse possession is also allowed under the law, under section 112 of Land Registration Law 2015. You can an adverse possession can also register. Yes, you can actually register under that law, under section 1121 of Land Registration Law of Lagos State. Okay, that's 1121. 1122 made provision for an adverse possession to also register. So, survey plan, usually what they will do, you must be able to show the fact that you're actually an adverse possessor, and then you have evidence of the fact that you've been in that line for long, and then quite a number of years as stipulated by law, and then you submit necessary documents to the register of title. The register of title has its first right of refusal. It can accept, it can refuse. The only thing is that it can never decide ownership. It cannot decide ownership. So you can also read the case of Majeko Dume against Abina. Majeko Dume against Abina. Now, another thing people can do, if you don't want that title to be registered, maybe you are interested, you can file an objection. There's an objection based on customary title. Objection based on customary title. If a family land is delivered for registration, For example, somebody has delivered a family land for registration. You could actually raise an objection to it. Okay? You cannot register a family title. You all know that Ekpendu against Erika and several other cases. Another objection is you can also place restriction. Caution. That's number 2. You can place caution. There are type of caution. There's a caution they face first registration. Once somebody file application for registration and it's advertised in the newspaper, you can place a caution. Okay, there's difference between caution and objection, though they have the same effect. Caution and objection. Objection may be based on the fact that this land doesn't belong to you because it belongs to the family. That could be objection. Caution is also similar to objection, but you have different purposes. Okay, for example, somebody who deliver a particular property for registration might not be the owner, or probably the owner having looked at the survey plan. If there's an overlap, or he discovered that the land that's also his land, so you can also file a caution against forced registration. Okay, that's one. Then number 2 is against dealing with the land. This is more or less friendly. You can actually place a restriction that the land belongs to our class of 2026 or 2024, as case may be. And as a member of that class, you can place a restriction on that particular piece of land. So when anybody wants to deal with that land, aside from any member of the class, or if the member of the class decide to now sell, they will ask somebody place a caution or somebody place a restriction. And when they find out if it's you, you're only telling them about the fact that you are interested. That's why you file it on that. Well, I'm not going to dwell much on that. Another thing I want to discuss is to what extent is your title guarantee? The fact that you register with the state government, to what extent does your title guarantee? Do you have title guarantee? Once you have a registered title, does it mean that your title is guaranteed? Yes, the title is guaranteed for first registration under Registration of Title Act. So it's like you are the only one we can deal with. The moment you have a registered title, you have a secure title with the state government. That does not mean that whoever can establish a better title other than you cannot do so, but that will be in court. So any dealing with you, once you register your first register, when you have your title register first, yes, you have a kind of title that is protected by law. That is where you have an animal shall against money. Animal shall against money. Because the only validity of transaction or dealings with any land that is registered as owner, you have ultimate power to deal with that land, and the state government recognizes you as the landowner. So once you deliver your title for registration, you are recognized. That's what I'm saying. So you have a kind of indefeasible title. Your title cannot be defeasible at that time until it's set aside by the court. So if I have my document registered for today, whether I'm the owner or I register as an adverse possessor, I register as even a thief, the land is guaranteed because I have a secure title with the government. Okay, so that is what I'm trying to let you understand. So the registered title owner remain the legal owner, notwithstanding the fact that there's an adverse title on it. Okay, so the reason why you can go and borrow money from the bank, if you go and borrow money from the bank, they will not collect your equitable document. A title that's not registered, they will not accept it from you, except for microfinance bank or some of these banks that just borrow money and just you will have traded your property to them. But I'm talking about real legal mortgage, real commercial banks. They will not give you any loan, and you want to use your property as a collateral. But the moment you provide a registered title, yes, your title, you have a legal owner, you are a legal owner of that particular title. You can also see the case of Riwayi. Riwayi against Aroma Sadun. Riwayi is spelled Rihawi, Aroma Sadun, Aromashadun. Riwayi against Aroma Sadun. So the old law, section 53.2, section 53.2 of Registration of Title Act, okay, try to give what we call indefeasible of title, okay, that your title is protected. But the question has always been that, is that not a limitation to the doctrine of nemo da qui non habet. You don't give what you don't have. For example, I've registered a title that doesn't belong to me. What is the law saying? The law is saying that I'm protected, notwithstanding the fact that the property I register does not belong to me. So that constitutes to me an exception to the principle of nemo da qui non habet, that you don't give what you don't have, because of the fact that if a subsequent landowner now present that thing for registration and somebody is now opposing that, then there's going to be a problem, because a subsequent owner is likely going to file, a subsequent person that want to register rather is likely going to file a problem. You can also read Yesufu against Ojo. So he's talking about the fact that yes, he gives what we call an indefeasible title, and is the only title recognized by the state. Then another thing you need to understand about registration: when people go to court, even as an adverse possession, people believe that the moment somebody obtain a certificate of occupancy and he have it registered, the land is good, and there's no anybody that can challenge him. That is not correct. The fact that you have a registered title on a piece of land does not mean that somebody cannot challenge your title. If I have a better title and I can prove it, I can establish it other than you, then I can go to court. But it has to be to the court, not for the registry of land registry. It's only court that can set aside. It's only court that can set aside that registration. So when people go to court, you go to court as against setting aside registration that was unlawfully done. That will be your remedy, and then you seek for what they call rectification of the register. Rectification of register. Rectification of register is talking about a situation whereby somebody has registered on your land and you have successfully challenged him in court, and the court has set aside that registration. Your second relief will be that rectify, remove his name and put my name, because having won the case in court. That is what I'm trying to let you know. Section 48 of land users actually incorporated by preserving all existing law. So registration law is actually no longer registration of forced register. For registration rather, is no longer necessary once you have a right of occupancy. But once you deliver it for registration also, that doesn't mean that you cannot create another multiple registration on it. That is what I want to say. Now, basically, my teaching is just to summarize the registration of title, registration law under the old law. My duty is just also to tell you about the fact that I told you from the beginning of this class that you need to get Lagos State Land Registration Law 2015. You can get it on your own. I will try to produce a book for you if people are not buying, but that's not even a problem. You have your rights. So let me mention this law briefly, because I've also set question on it, and I'm telling you now. What I want you to read, go and read chapter 2 of that book. Chapter 2 of that book is the Lagos State Land Registration Law 2015, Prospect and Challenges. It's an article written by me in that book. It's a chapter written, I wrote chapter 2. Go and check chapter 2 of that book and read chapter 2. What are you trying to look for in that book? That chapter. Look for what they call innovations introduced by Lagos State Land Registration Law 2015. Okay, now if you look at that law, what are the salient provisions of that law? Section 2. Section 2 called instrument document. I think I mentioned that to you. It called instrument document. That's section 2. And section 2 of that law, I say every document of interest in Lagos State shall be registered in accordance with the provision of this law. So section 2 about document. Section 2 talk about documents, and then also the land registry is also recognized. Then registration of landholder. But what I want you to actually read in that chapter 2 is innovations of the law. What are the new things that the law has introduced, so that I can allow you to go? What are the innovations that this law has introduced? Number 1 is priority of interest. It gives us priority of interest. It has now become more conspicuous, unlike what you have been taught in class, that once you register, when they are equal equity, the first time prevail. It expressly provided for under that law. That's priority of interest under section 29(1) of LRL. That's Land Registration Law of Lagos State 2015. So you now have that law specifically provide for interest and then priority. So you have 29(1), 29(2), 29(3), 29(4). Number 2 innovation is what we call registration of judgment. Registration of judgment. Registration of judgment is talking about now under section 58. Though it's there, you can actually register judgment. That is what we are saying. If I have taken you to court and I've taken judgment against you, how would the government know that somebody has won? So what I would do is to go to court. To go to land registry and have my land, and the judgment register against that land. So the law has also provided under section 58 for registration of judgment. Okay. In fact, it also confer anything from the writ of anything affecting that particular case that the court has decided in your favor, you can register it. Then number 3, fees for registration. It has actually improved upon what you are going to pay for registration under the second schedule to that law. You have it there. Then number 5, registration under Land Information Management System. Registration under the Land Information Management System, that is LMIS. Registration under the Land Information Management System, LIMS. It's talking about now system is being computerized. You now have law that now give them backing to deliver for registration. One of the problems in Lagos State, if you go to land registry in Alausa, they will tell you that it's not LMS, so LIMS is down, the system is down. They only have that problem, but that's not even what we're saying. So section 17 of the law now said that all documents have been registered through use of LIMS. So you now have that, which says that it must be registered through LIMS. So that's another priority, innovation. Offenses is now clearly defined under, that's another section 74. Offenses has now been clearly defined. So what constitutes offense under the law? If you willfully destroy document or registration, if you willfully file a document or counterpart of it, fake of it, if you deliver for registration under section 74 of that law. Then you also have caveats, caution, and retrievable document under section 69 to 70 of that law. Now, section 89 of that law allow family representation. It was not there before. Family as a group present document for registration under section 89. Family can now registration. That's section 89. Salami Olamide, you are raising up your hand. Anything? I saw Salami. Who's Salami?
Good morning, sir. I want to ask a question, sir.
Yes, who's Olamide Fasaji? You are disturbing the class. Yes, you go on.
All right, sir. I wanted to ask the question earlier under registration. Other question.
Let me conclude this teaching because I was so round up.
All right, sir.
Yes, so let me conclude. So I was talking about family representation, section 89. Section 89 deal with family holding. Requirement family can hold meetings, appointment of family representative for the purposes of registration. So it's now recognized under section 89, section 90. Then another thing is rectification of record. With all consent of party, you can even present document for rectification now. Just like what I said. You can actually present document for rectification under section, I think that's section 51, from section 1, section 51, section 39, section 53, you can present document for registration. Then grievances and remedial mechanism. Aggrieved parties, if you are aggrieved, you can actually go to register of title by taking your documents and everything there. Okay, so that's what you can do. under that law. But in case registration of title under section 1062, under section 1062, where a matters have been decided under section 1062 and you are not satisfied, you can go to High Court. So High Court is what you can go to if there's any grievances about your refusal to register, and then these are things you need to understand. I will stop here, but I commit that chapter 2 to you. Just like I said, I've said question on it already. I've said question on land registration already. And then, I don't know, you have option to answer many other questions, but I believe that usually this question is always the cheapest one of all the questions. Okay, so I can listen to your question. I want to round up. I have some other thing doing, and I want to go. Yes, Salami, what's your question? Now you must speak up. Let me hear you.
All right,
Yes.
all right, sir. Good morning, sir. My question is under registration. Well, you said it will be advertised on the national daily newspaper.
Yeah.
So upon advertisement, can a bystander object to it? That is someone that does not have any interest, but know someone that has the land, or know someone that
Yes.
has interest in the land.
You may file your caution, but it's not automatic. Once you file caution within, you have time within which you file. If you don't file within the time, then you won't be able to complain, because you must have been seen to have slept on your right. Yes, you can do that. You file a caution, that's dealing with the land. You can just file a caution, and if you do that, then they are likely going to invite you and invite the owner. You bring your documents, but you can't go there if there is no document you want to substantiate your objection. Okay, so if you are going there because they are going to invite you, register of title will invite you, just like I said, it's going to invite you and it's going to ask parties to bring evidence of ownership. Okay, and if he's not satisfied or is satisfied, you rather register the person or refer both of you to court to go and determine your title. I don't know whether you understand. Do you understand? Have I answered your question?
Oh, yes, sir. Yes, sir.
Yes, another one. Yes, I saw Mary.
Good morning, sir.
Yes, good morning.
After you mentioned rectification of register earlier on, you mentioned the section 40 and something about registering multiple interests. I didn't really get that, sir.
I was talking about rectification. What is rectification? Rectification has to do with correction. Okay, if it's rectification you're talking about, how to do with correction done in a land that have been registered. Okay, that have been registered. That's what I said. And I said, number one, rectification can only come in, though under this new law, yes, rectification is allowed, is permitted, or is permissible as the case may be, because it's part of the innovation under section 11 to 51 and 51 of that particular law. That's what I said. The other one I was talking about is, I don't know, multiple interests in land can be registered depending on what you are registering. You know that you can have multiple of interests registered on the same land. It's possible for you to have the same land subject to mortgage, the same land subject to lease, the same land subject to an easement right. This is what I was talking about multiplication of registration. I don't know whether you get what I'm saying. By now, you should be able to distinguish between registration of title and registration of instrument, or what we call registration of document, under section 2 of land registration law of Lagos State. That's what I'm saying. I don't know whether your question has been answered.
Yes, sir. Thank you.
Okay. Well, so we'll stop here. I will see you tomorrow for your test. Your test will hold 12:30. The same time you are going to do land law class, you are going to use for trust test. Okay, thank you. Have a wonderful day.